Hello, hello, hello. It's Attorney Mark Graven coming to you from Chicago. As usual, we're at the end of the Lau adventure, or at least we're at the end of the available material for the Lau adventure. Let's get this thing going, shall we?
Okay, we can go on the record whenever you're ready. Okay, good afternoon. I have Ms. LeCompte here in the virtual courtroom. We have Mr. Reynolds and Officer Cochran here as well. Mr. Reynolds, are we ready to proceed today?
I don't know, but I highly doubt it.
Yes, I have. We are, and I haven't seen any new photographs that Ms. LeCompte has submitted, but I have Officer Cochran today.
And I thought we have something on. So we've got Ms. LeCompte here. I did see that there was one document that was uploaded. Did that come from the city attorney's office?
That is correct.
Okay, so has that been shared with Ms. LeCompte?
It has.
All right. So, and I can see you there, Ms. LeCompte. Are you ready to proceed today?
Not quite, Judge. I have a few questions.
Okay, why don't you go ahead?
Because I'm confused about the proceedings okay, first I asked probation to change my name on this.
You don't have a question.
In my thumbnail here. That's not my
is.
formal name. It's not what I use in formal proceedings. I don't know how I got there. And I would like to change that and the affiliation because it's not appropriate.
Here's my question.
I did not enter.
Ma'am, are you a whore?
Well, let's see if we can change that for you.
How would you like it entered in, Ms. LeCompte? Is it just on your case file? That's not something that our Zoom pulls automatically. It would have been something from your device. I'm not exactly sure how that is, but how would you like your name entered in on your Zoom?
I would like it to be Margaret LeCompte.
Okay.
And no Safe South Boulder.
Yeah,
that's
of course.
not appropriate.
I understand. Give me just one moment, ma'am. Do you see that name change now, ma'am, Ms. LeCompte?
Thank you very much.
Yes.
And Judge, I
haven't tried
a
yet.
question about just what's happening
But
today
thank you.
because I'm not clear.
Okay, so I'll just pull up my last, the face sheet from April 8th and I'll tell you what it says. And then we'll go from there. We had a hearing on April 8th. And it was a hearing, a show cause hearing to determine if you were in compliance or not in compliance with my original sentence from October 8th. We'd had previous hearings in January and other dates. And then the April 8th hearing was a hearing to determine if you were in compliance or not in compliance with the court's order. At the end of the process on the 8th, we decided to continue the hearing over to today's date so there could be additional evidence provided before I made a decision with respect to whether you were in compliance or not in compliance. I think I had said on the prior hearing that I had found that you'd failed to comply. I had imposed and stayed a sentence, and I'll go back and talk to you about that. Let me pull that up. That was the prior date before April 8th. So give me a moment to pull that one up. So on March 17th is actually when we concluded the hearing. I found that you were still not in compliance. I imposed the $2,150 fine. I suspended $1,650 of that fine. I imposed 64 hours of community service. I suspended 48 hours of that community service.
Your audio is.
It's probably on your end, Ms. LeCompte. Why don't you turn off your video? You don't have adequate bandwidth probably on your end. So why don't you turn off your video and that might help you hear better.
All right, let me see. Hang on. Okay.
Okay, so maybe I'll just start over so we can make sure you hear what I was saying. So
Okay,
on
thank you,
March,
because I didn't. Thank
that's
you.
fine. We'll start over. On March 17th, we had a show cause hearing. At the end of that hearing, I concluded that you were not in compliance with my original order. I imposed the $2,150 of fine that had remained. I suspended $1,650 of that fine, leaving a $500 net fine for you to pay. I stayed that fine to the next court date. I also imposed the 64 hours of community service that had been left open in your case, and I suspended 48 hours of that. So that meant that you had 16 hours of community service that you would have been expected to complete. I stayed that 16 hours until the next court date in hope that you would be able to come into compliance before that court date so that I wouldn't have to have you perform the community service or pay that $500 fine. On April 8th, the parties appeared, and on that date, we had additional evidence that was presented. At the end of that presentation, and if you'll recall, there were photographs that were submitted by both the prosecution and by you. At the end of that, we determined to continue the hearing over so that I had a stay of execution, which means you weren't required to perform the 16 hours of community service that I had imposed on March 17th, and you weren't required to pay the $500 fine. We had a hearing to determine whether to continue that stay of execution or to require that you pay the $500 fine and perform the 16 hours of community service. At the end of the hearing on April 8th, we said, well, let's have some more evidence because you were making some progress, and you had indicated in the last hearing that you anticipated that you would have the trailer out and you would have everything in compliance by another court date. So we rescheduled for today's date. So the purpose for today's date is to have additional evidence for me to consider to determine whether I'm going to require that you pay that $500 fine that had been stayed and the 16 hours of community service, or whether to move forward in a different way. And so I'm certainly happy to hear other evidence from either you or from the prosecution. I will first turn to Mr. Reynolds and indicate that if he would like to call a witness and admit exhibits, he certainly has the opportunity to do that in today's hearing, and you would have the same opportunity if you chose to do so.
Judge, I still have a question.
Okay.
I understand that today, the hearing today is, according to what you said in our last meeting, was to be only about the issues on the north and the west sides of the house, and specifically not the backyard. And
That's
now
correct.
all right. So now it appears that there is another motion to add a charge, which Mr. Reynolds has forwarded to me.
Oh my
I
God.
don't know if that
She really is worse than Lau.
that motion has been granted.
She is.
And while I could assume that it's about the backyard, I shouldn't assume that because I don't know what that charge is specifically about.
Okay.
And so I'd like to know that, to know whether we're, are we talking about the west and the back and the side yard, or we're talking about the backyard as well? And if that's the case, I really do have a serious concern about that, because I had tried to schedule a pre-hearing conference with Mr. Reynolds, but as I told him, I've had a couple of serious medical issues, and I couldn't schedule it last week, and suggested it be done this week. So now I'm sort of in limbo. I don't know whether we're talking about March 5th or whether we're talking about October 2024 or both.
Yes, those are fair questions. Today, my purpose is to focus on the 2024 case.
Okay.
And that's case number 2024-2250. So they have different case numbers. So that's the case that was from 2024 that we've been talking about consistently since really October. For me, my engagement in it was October when I took the plea. So that's the case we're here for today. The other case that has been filed, we've been, what we call in court, we're trailing. That case is just kind of following along with this case, but nothing's happening on that case yet. So that case is trailing. The motion to amend that was filed by the prosecutor's office pertains only to that new case. And the rules of procedure allow the prosecutor's office to amend, which is to add another charge, as long as they do so in a way that doesn't create any prejudice to any party. And I define prejudice here in my mind as whether the party is prepared for trial based on only one charge and has already been advised of their rights on the charge and entered a not guilty plea and set the case over for trial, none of which has happened on that new case. So the motion to amend to add charge was filed before you've even entered a plea. And so I've granted that motion, which I would do for any case that's filed in our court where the defendant hasn't yet entered a plea of guilty or not guilty on the original charge. So that motion to amend has been granted. It's allowed by the rules, but it is not subject of the proceedings today. It may relate to the backyard. Their evidence may relate to the backyard, but we're not focused on the backyard today.
Okay, thank you very much.
You're welcome. Any other questions?
I assume Mr. Reynolds is going to say at some point what those charges are that were added.
Well, they were, let's not focus on those right now. If you want to have some follow-up on the conversation after we deal with the 2250 case from 2024, I'll certainly allow you and Mr. Reynolds to have a conversation. And I can certainly share with you what the motion to amend says and what the extra charge is. But let's stay focused for right now.
Okay.
Just on the 2024 case, and I'll be happy to address the other case with you later.
Okay, and to that end, there are some more pictures coming that were taken in mid-morning today.
And so you're sending those by Mr. Lau sending us some new photos?
Yes, he is. I
Okay.
don't know if he's done that quite yet.
All right, and I understand that this where you're at, but I want to encourage you, if we have additional photos that are going to be submitted, to do so in advance of the hearing, because then it puts a pretty big burden on our clerk to try to navigate being a clerk in the courtroom on things that are happening in the courtroom, and then trying to go to her email and upload various photographs. Those should be submitted in advance of the hearing. So I know we've kind of scrambled in the past to assist you with that, but going forward, if there are going to be any kind of hearings involving documents or involving photographs, would want you to submit those at least a day in advance, or at least in the morning. And I know the prosecutor may have taken his photographs in the morning, but they're in the file, and our clerk didn't have to do any work right while she's in the courtroom, because it just puts a lot on our staff to try to do that. But understand.
Okay, I do apologize.
That's okay. I just want to make it clear going forward. We'll deal with what we have to deal with to get them uploaded so that we can consider them. Anything else that you want to address before we get started?
No, sir.
Okay. Mr. Reynolds continues to be in the court's view your burden of proof on these issues. Did you have any additional evidence that you wanted to submit, either in the form of testimony or offering exhibits? I know something's been uploaded, but I think we would have to at least have some foundation laid for it.
Well, I suppose, Your Honor, at the last hearing, we continued it so that Ms. LeCompte could demonstrate that she is going to get into compliance. Because we haven't had any evidence from her end about that, then I have my officer here, but in the city's mind, the absence of Ms. LeCompte providing proof that shows that she's in compliance with probation is a violation in and of itself. This is like I don't even know how many numbers of hearings that we've had about this. It kind of strains credulity that she would not understand that it's her responsibility to show that these loose items are picked up. And that while I have the officer here to perhaps, rebut any evidence that Ms. LeCompte wanted the court to consider in terms of the way that photographs are taken, I just would hate to be here, months from now and being in the same situation of kind of waiting on Ms. LeCompte.
Oh, we'll be here months from now. Okay, for the record, that's number 2. I had number 1 during the last stream. It's number 2. I think I've got 3 in the place. So I don't think we're in any danger of me going full Ricada. Because I know you never go full Ricada.
Show how she's brought this property into compliance.
And I think to some extent, I would agree with that. It is at this juncture, Ms. LeCompte's obligation. I called attention to the fact that because you had submitted a document and I didn't know whether you wanted to proceed with providing that documentation. I don't need anything else from the city because as we ended on April 8th, I had already seen evidence from the city that showed that the defendant was not in compliance. And that was from March 17th. And then it was continued again with additional information on April 8th. So the problem that we have is we're waiting for Ms. LeCompte now to load photographs that she has, we're 1:30 p.m. and there are photographs that are now being emailed to our court clerk. And I share the frustration that we shouldn't be in this position where the day of the hearing and after the hearing is scheduled to begin, we're uploading documentation from Ms. LeCompte. Having said that, I would rather rule on the merits of where things really are rather than hold on to some formality as to the start time for the hearing.
So we're ready to proceed with the continuation of the show cause with Officer Cochran's testimony, and I can, through testimony and the exhibit that has been provided to Ms. LeCompte, the pictures can proceed now.
All right. So if I'm reading you correctly, since we don't have anything uploaded yet from Ms. LeCompte, you want to reverse the order and offer your testimony and exhibits?
Yes, in the interest of time, though, we're happy to do that.
Okay, thank you for that, Mr. Reynolds. All right, so did you want to call Officer Cochran to testify?
Officer Cochran, and if you want to perhaps slide over here, you can bring the chair and then speak into this microphone.
And Officer Cochran, if you'll raise your right hand for me, do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you, sir. And go ahead whenever.
I actually did pay Alyssa one time. And nobody will believe this, but it's absolutely true. It was for some annoying, intricate corporate crap I didn't want to do. I'm not making that up.
Whenever you're ready, Mr. Reynolds.
Thank you, Your Honor. Officer Cochran, can you please state your name and spell your last?
It's Benjamin Cochran, Cochran.
And where do you work?
I work for the Boulder Police Department in the Code Enforcement Unit.
What are some of your duties in the code enforcement unit?
I enforce portions of the Boulder Revised Code that relate to property maintenance standards, such as.
If a judge acted like this in Chicago, they would just get run over so hard day in and day out. It would just be open season. Every attorney would be like, look, you can just do whatever you want. It would be ugly.
Trash storage, tall weeds, noxious weeds, things along those lines.
And are you familiar with the address of 290 Pawnee?
I am.
How is it you're familiar with that address?
290 Pawnee is an address that we've had extensive enforcement action at, both for this specific case as well as years prior. Both myself and some of the other officers have also taken enforcement action there in the past.
And when was the last time you were at 290 Pawnee?
I was at the property this morning.
What was the purpose of you going out there?
I was at the property to take photos and document the current conditions that were present on the property.
I'm going to now share my screen on Zoom with what's been marked as People's Exhibit 1. There's a few People's Exhibits 1 in this case, but this is People's Exhibit 1 for 4/22/25, which is today's date. So Officer Cochran, if you wouldn't mind just glancing up at the screen, and I'm going to just scroll through these photographs here. Can you just tell me if you recognize these photographs?
Yes, I do.
How is it that you recognize them?
These are photos that I took this morning.
Do they appear to be fair and accurate representations of the area of 290 Pawnee?
Yes.
I move to admit People's Exhibit 1 into evidence.
Ms. LeCompte, do you have any objection to People's Exhibit 1 being admitted? I think you'll need to unmute to your microphone.
Okay, I don't have any objection, but I think that the pictures that I have will show that they are different.
Okay, exhibit 1 will be admitted. And we'll take a look at whenever the other documents are submitted to us.
So Officer Cochran, I believe this is, these are 6 pages of photographs. So it's 6 different photographs. So we'll just kind of take them one at a time. So we're looking at the first page here. It represents, was this taken from the north side of the house?
Yes, this was taken from along Sioux Drive, looking south towards the north side of the property.
And can you see my cursor as I kind of move it around the screen here?
Yes.
All right, so the area that I'm circling here, what is this? What is this?
It appears to be some form of lumber, possibly 4x4 fence posts, but definitely some kind of wooden lumber material.
And would you characterize this type of wood as firewood?
Personally, no, I would not.
Okay. And is this lumber a new appearance since the last time you were out there to take pictures?
Yes, to my knowledge, that was not there at my previous visit to the property.
All right, I'm gonna scroll down to the second photograph on People's Exhibit 1. What is this a picture of?
This is a photo taken of the driveway area of 290 Pawnee from the west side of the property.
And can you see my cursor here circling this kind of the middle of the second
Yes,
photo on People's Exhibit 1?
yes.
How would you characterize what I'm circling right here?
It appears that it would be, there appears to be a dolly of some kind, a shovel, wire racks or grates, just kind of loose items, metal items, I suppose.
And then if you zoom in here, the brick facade of the building,
Yes.
the house here, kind of comes to a corner with the white wooden, perhaps dual doors here. Does it appear to be that there's more loose property in that corner of the property as well?
Yes, it does.
Then there's this little white rectangular object behind the large juniper bush. What do you believe that is?
Based on previous visits to the property, I believe that's a freezer or a refrigerator of some kind.
Okay. Now the third picture here, was this taken from the Sioux Drive side of the property?
Yes, it was.
And you're familiar with this part of the property as well?
Yes.
Does it appear that the loose property that's been the subject of these proceedings has been removed from this part of the property?
Yes, it appears that there were some items that were there, but it appears that the majority of them have been removed, except for the firewood that's there.
Thank you. All right, I'm scrolling down. The fourth picture on People's Exhibit 1, was this taken from the Pawnee side?
Yes, this is from the Pawnee side looking northeast towards the property.
Do you remember Ms. Lecomte testifying about this refrigerator here?
Yes, I do.
Do you recall that she had stated that she was waiting for Excel to pick it up?
Yes, I do recall her saying that.
And this refrigerator, is it actually on the property of 290 Pawnee?
No, where it's currently located in this photo is in the front yard of the property to the south, which I believe is 260 Pawnee Drive.
And do you know if anybody is currently residing at 260 Pawnee?
As far as I'm aware, no, it's currently vacant.
But it's your understanding that this refrigerator belongs to Ms. Lecomte?
Yes.
All right, so the fifth picture on People's Exhibit 1, I'm going to just zoom in, and then again, Officer Cochran, do you see my cursor on the screen?
Yes.
I'm circling this material that's on the back right portion of the large white trailer. How would you characterize the property that I'm circling here?
It appears to be just kind of a pile of various objects. I believe I can see maybe some snow shovels, some possibly piping or tubing of some kind, but it kind of just looks like a pile of random various items.
And I'm going to scroll down, and then this last picture on People's Exhibit 1, is this taken from the Sioux side?
Yes.
And this large wooden pallet material here, was this there in your previous visit and this on the lawn of the Sioux side of 290 Pawnee?
No.
So does this appear to be new loose property?
Yes, to my knowledge, it's new property.
And I don't have any other questions for Officer Cochran.
Ms. LeCompte, do you have any questions for Officer Cochran? You'll need to unmute.
No, I don't have any questions.
Okay. Officer Cochran, you can step down. Any other evidence from the city?
That is it, Your Honor.
Okay. Let me just turn to Sabrina. Do we have anything that's been emailed to you or?
No, I haven't seen anything to either my personal work email or to our B-Desk.
Judge, I believe it was sent to Fernanda Bittencourt.
That's a problem because Ms. Bittencourt is not here today. She's off for the
Okay.
last 4 days.
Okay, then we'll send it to B-Desk.
Yes, that would be great.
Okay, great.
All right, we'll pause for a moment. Probably take us about, I don't know, 3 or 4 minutes to get everything emailed and then uploaded. So I'm going to go off camera for a moment.
Attention, esteemed viewers. If you are hearing this message, it means that you are sadly witnessing a dark moment in the history of legal discourse. Yes, it's true. Law Talk with Mike is experiencing what we in the business call a plot hole-sized lull. This is, of course, due entirely to Mike's, let's say, ambitious approach to preparation. And by ambitious, I mean utterly devoid. Yes, the very fabric of our legal system, as represented by this live stream, has encountered a, shall we say, temporal anomaly. A glitch, a hiccup, a veritable vacuum of action. And who is to blame? Why none other than our esteemed yet woefully unprepared host, Mike. So sit back, relax, maybe grab a snack. This musical interlude is just gonna be a thing. We'll get back to the legal stuff eventually, probably. So to fill the gaping void where insightful
I know who's on my
legal
team.
analysis should be induced to a lack of any ability to keep your attention, Mike has in his infinite wisdom decided to subject you to this artistic expression. God help us all. Please do not hold Mike accountable for this. Bless his heart, Mike didn't quite foresee these moments of dead air when he planned for
Time to hit the cocktail if you got one.
He clearly has no idea what he's doing. So sit back, relax, and maybe grab a snack. This musical interlude.
I don't know what his deal is.
You sent it to B-Desk?
We'll get back to the legal
Okay, thank you.
stuff eventually.
Yes,
probably.
Miss LeCompte, you did receive it. I'm uploading it now, okay? It just might be another minute or two, couple of minutes.
Okay, thank you. I'm not seeing them, but I'm not supposed to, right?
Yeah, they just haven't been uploaded yet.
Yeah.
That I gave Ms. Milligan, I'm assuming bacterial vaginosis.
Meaning she was bleeding out of her hoo-ha.
Your Honor, I am a neurodivergent person with complex PTSD
Mike, please turn off your video because the audio does not come through. Yes, I can see you.
It's off.
Now we're back on the record, Ms.
Ms. LeCompte, you just might want to mute yourself because we were hearing your conversation with Mr. Lau.
Oh, I thought she was talking to me. Of course, it's Mike Lau.
There is no schedule at Law Talk Nation. You can only pay, get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got pre-trial on the dial. Letting always make your chest smile. The pros say can't ever share a file. Defendants are always in denial. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day of Law Talk with Mike. Courtroom is always popping off. You have a failure appear and you scoff. Judge Simpson is never going soft. Webster is always showing heart. We are heading into that soft 6 summer.
All right, so Mr. Kopp, we do have documents that have been submitted as defendants exhibits A through D. They're now in our full court system. And I'm going to ask Sabrina to share her screen and just share your screen for defendants exhibits A through D, which are four different photographs. I don't want anybody to comment on them. I just want you to be able to see what we have.
Okay, just moments or so I can get out of some things for security reasons.
Number one, wrong. Know what I'm saying? Number one, wrong. Know what I'm saying? We are the Law Talk with my crew. Number one, wrong. Know what I'm saying? Number one, wrong. Know what I'm saying? Number one, wrong. Know what I'm saying?
Can everyone see those?
Oh, I've got some soup coming from Food Fairy.
Ms. LeCompte, are you able to see the exhibits that are now being shared by Sabrina?
It's good stuff.
Yes, I am.
Okay.
Seriously.
So the
Oh,
next
I know what
step
you
of this
missed.
process, as we've discussed, it is your burden to establish that you are in compliance, full compliance with the court's order to not have any loose property on the premises. So you have the option of testifying if you'd like. Someone has to lay the foundation for the admission of these exhibits. They've been submitted, but someone has to indicate what these photographs are, where they were taken, when they were taken. So if you'd like to testify, I can swear you in. If you want to call Mr. Lau to testify, you can call Mr. Lau. Either way is up to you.
No, I'll be happy to testify to it.
All right, so I'll just ask you to raise your right hand for me. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you, Ms. LeCompte. So you can, and if you need to just ask for
There shall
Sabrina
not be any
to maneuver
cutting,
these
please.
documents, feel free, but if you'd simply like to tell me what we're seeing. The first photograph is in front of all of us. This is denoted as Defendant's Exhibit A.
Okay. Would it be possible for me to flip through and see what they are so I have an idea?
Yes, she can just scroll down and show you each
Yeah.
one.
So that would be B, Ms. LeCompte, the second.
Okay,
picture.
thank you.
And then moving down, this would be Exhibit C for you, Ms. LeCompte.
Okay.
All right, and then this is the final one, Exhibit D, that I received in the email.
Could we go back to Exhibit 1?
Yes, ma'am.
And we'll call that Exhibit A, but yes, the first picture is Exhibit A.
Okay. So this is the, I've taken from the from the northwest corner of the house, looking east. And it's the north side of the house. It doesn't show some of the offending things that are now gone, but I'd like to list what they are, because they're basically between these three big crabapple trees and up against the house. There are a number of items that were of contention in our last hearing, and I'd like to itemize what they are, because they are no longer there. And I have another picture, but it doesn't, which shows basically the sidewalk view looking straight in towards the house itself. And it will show you that the pallets by the sidewalk, which were over on the left-hand side in Mr. Cochran's picture, sort of where the yellow spot is, which is the end of the guy wire that holds up the telephone pole. But basically there were a pallet and a sort of a half of a pallet there. That's gone. There was
Well, let me just stop you. Let me just stop you and ask you to clarify, if you don't mind. You're talking about this, what's more in the front of the house that's on the Pawnee side, right? With the pallet.
This is actually on the Sioux Drive side.
But when you were talking about the pallet, when Officer Cochran was talking, he was showing a photograph of the pallet that was on the Pawnee side. Is that what you're talking about?
No, he had another picture of one that showed a pallet right on the edge of the sidewalk. Two of them that were right on the edge of the sidewalk on the Sioux Drive side.
Okay. And they're gone.
That's right. If you could pull up Mr. Cochran's photographs of the north side, I could show you what is missing.
Okay, well, we can, so let me try to think of the most efficient way to do this. Why don't you hold that thought and remind yourself that you'd like to. Let's stick, because otherwise we have to leave this exhibit and share.
Okay.
So just keep talking about what we're seeing here with this particular set of photographs.
Okay, you're seeing the northwest corner of the house,
right?
Into the straight down through the side yard to the south, and you'll see that the only thing that's in the yard there is a hose, which we were using to water some bushes, and there's a little orange spot against the shrub, that the crab tree, that is a little sculpture, a little yard garden sculpture. Towards at the back of the photograph in the middle, you'll see our wood pile. And in between that wood pile, moving towards the west, there were some 2x4s and other lumber, which has been removed. It's gone. And that was a point of contention in the our last hearing. There were also some green pipes that are tubes that were from my crawl space, and those also have been removed, but you can't see them in this picture. You can see them in Officer Cochran's pictures. The other area that Mr. Reynolds mentioned was some actually they were referred to as lumber, but they're actually railroad ties that are used to demarc the decorative barrels that we have right on the corner of the house there. It's not firewood.
So what were described as perhaps 4x4s, you're really calling railroad ties.
That's right. Okay, so could we go on to the Exhibit B?
We can.
This is the front porch, looking from approximately the front door to the south. One of the bones of contention were the two little freezers that were there, they're gone. And this was pretty much cleared out in the previous pictures that we showed, except for 2 bags of mulch, one of which is still there. The gentleman who was going to spread that for me got sick and couldn't do it. The other one is in a little mulch spreader that we have on the premises, and that will be done just as soon as he can come, which will be this on Sunday morning, I believe. And I think that's all to show on that, other than there's no other loose anything on the front porch.
Okay. We'll scroll down to the next exhibit.
This is the driveway, looking at the from the south to the northeast. You can see at the edge of the driveway there, at the edge of the house, there's where the freezers were, and they're gone. There are no other items underneath the juniper bush. That was a bone of issue in the past. They're all gone. The items that were in back of the trailer is obviously gone, and all the other equipment that was on the driveway is gone. Those were either in the trailer or right at the back or near it, being ready to be loaded when Officer Cochran went by this morning, and they have been picked up and moved. Can I see the next picture? Here's another picture showing that the stuff that is to the right of the garage that was in back of the trailer is gone. The picture doesn't show it, but the refrigerator, which was actually on the easement of between my property and 260 Pawnee, is gone. It had a sign on it to be picked up. It wasn't picked up, and so now it's gone. And I think that those are all the photographs, and I think that is all the comments that I have about things that are gone. But I think it demonstrates that just to the left of the juniper bush, that is the mulch spreader with the other bag of mulch in it, getting ready to be spread out later this week. It's not, it's not mulch, it's a yard fertilizer. And I do very much apologize for the delay in all of this. And I will, should there be more photographs or documentary evidence for me to show, I will make sure that, as you requested, Judge Kahn, that they will be there at least the day before the hearing. I don't like this brinksmanship myself at all.
Okay, nor do I. All right. Any other testimony that you want to offer?
No, other than I think my yard looks a lot better, and my flowers are growing. I hope that it will continue to look that way. And I don't just hope. I much prefer it looking this way.
Okay. Mr. Reynolds, cross-examination.
Good afternoon, Ms. LeCompte.
Good afternoon.
I might actually just stay seated. Ms. LeCompte, the property that was removed between approximately 9 this morning and right now, basically the differences between Officer Cochran's photos and your photos, did that property go somewhere else on your property, or where did it go?
No. Most of it went to a donation box that of the things that are, and we have documentation for that. Most of it was ready to be sent to a donation box or to be hauled away in the big trailer. And so that is where it went. It was ready to be moved away. Officer Cochran got here before we had a chance to do that, but that was in the plan. And as you can see, it has happened.
And where is that trailer right now?
The trailer's been taken to it's off-site at a on the. I'm sorry, I have to get a clarification from Mr. Lau.
We can see him. I don't want him to enable his video, but he can go to your with you and share that information so you can answer that. That's okay with the
Then
court.
Mike, you want to unmute
No,
your?
I don't want him to unmute. I
No.
just want him to tell you so you can testify because he's not under oath right now. Ms. LeCompte, you can go ahead. I think you're muted, so you'll have to unmute again.
I apologize.
That's okay.
It is hooked up to a big heavy truck on the north side of the property. We did not exactly have time to take it to the storage facility, which is on Arapahoe. It is called Extra Space, and that is where we have rented space to store the things that we really want to keep and not donate.
I don't have any other questions for Ms. LeCompte at this time.
And can you repeat that? It's on Arapahoe, and it's what's it called?
It's called Extra Space. It has had many names there in the past, but it's a storage facility that is just east of 55th on Arapahoe on the north side.
Ma'am, are you a whore?
And so you have an agreement to take that trailer to that particular location, the Extra Space location.
Yes.
Okay. Just wanted to clarify that. Thank you. And Mr. Reynolds, you're done with your cross-examination?
I am, Your Honor.
Ms. LeCompte, anything else that you'd like to testify to?
With regard to these photographs and things, no.
Okay. You also have the opportunity, if you choose to call other witnesses. If you think there's anything else, I don't need duplicative testimony, but if you have something else that you want to ask of Mr. Lau, you can have him sworn in, but I don't know that's necessary. I'm just saying that you have the opportunity if you think there's additional information to submit.
I don't think there's anything that's really relevant. Thank you.
Okay. So the defendant's arrested. And anything else in rebuttal from the people?
No, Your Honor.
All right, we'll start with argument then. And technically, the burden has shifted to you, Ms. LeCompte, to show that you're in compliance. Do you want to make any statements regarding whether you're in compliance or not in compliance at this juncture?
I would say that right now, with respect to the north side of the west side, that we are in compliance and do not have any plans whatsoever to bring anything back to the property such that like the things that have been removed, because they are essentially Mr. Lau's tools and his projects and other kinds of things. And they were not originally on my property and they are not coming back. I simply have to ask the court to accept my assertion that this is the kind of outcome that I would prefer, and and that I will not let this happen again. I have had some difficulty in getting things moved to my satisfaction and on both my own and the court's deadlines, and I apologize for that. I have well, I think I'll just let it go at that.
Okay. Mr. Reynolds, closing from the city.
Thank you, Your Honor. The city would contend that it did demonstrate that the property wasn't in compliance as of 9:05 this morning. And we are worried that that Ms. LeCompte gets the property looking as best possible kind of during the time period that we're having these hearings. But that's not what the city is worried about. We're worried about what happens before and after the hearings occur. And so I understand that Ms. LeCompte stated that she's not going to bring the property back. And I would hope that the way that she's demonstrated the property looks now with her exhibits A through D, that's how it would remain, that we don't get the code enforcement or our office doesn't get calls and emails in the coming days that a bunch of loose property is back. That the point is not just to have property cleared for the purposes of the time period of these hearings, but just cleared, period.
Oh my God. I'm grateful that he's saying, no, this isn't good enough. I don't trust her. I'm grateful that he's in substance going the right way, but just say that and move on. We have, based on our history, we have serious concerns about this going forward. Next.
And not have trash and junk kind of accumulate on the property. So, I think that what Ms. LeCompte submitted today as evidence of compliance, that should be kind of the regular state of the property. Obviously, one of the photographs shows the garden hose. That is not going to be give anybody any sort of heartburn, but tires, junk, metal things that accumulate, we've talked about over and over again, that's going to be a problem. So hopefully, while we do think that we have demonstrated that the property was not in compliance today and that the court could find probation violation just off of that, since it's not just like for a 1 hour period, the property is cleared, but that it is cleared and remains cleared. And it did not remain cleared as of this morning. So I guess what the city is asking for is that the order remain in effect, that she's on probation for the 2 years. I think it was starting in October of last year, so through basically October of 2026. No loose property can accumulate around during that time period, and even afterwards, if she's off probation, that more code enforcement actions can be taken if it happens again. But we are pleased with what she has shown.
All right, thank you for that, Mr. Reynolds. So I think the point that Mr. Reynolds has made is an important one for you to understand, Ms. LeCompte, is that technically the way the order that was initially issued by the court on October 8th of 2024 was that the property not have any loose property for a 2-year period on the property, which, yes, I can schedule hearings and we can take evidence on that, but it's true that from a very technical, not just technical perspective, but an expectation to the court's perspective is that the property doesn't just have a lot of items on the property from April 8th through to until April 22nd, and then at noon on April 22nd, it comes into compliance, and then at 5 p.m. on April 22nd, there's more items of property, or 2 days later, there's items of property. The rule is continuous, that it remains in compliance and doesn't have loose property. And so I want to just stress that and make sure that you understand what that means. It won't be an isolated picture
Straight to jail
that the
now.
court takes on one day. It'll be, what is the state of the property through the 2-year period? That's the expectation. So that I want to be really clear with for you and for Mr. Lau, who obviously may have some influence on what ends up on your property. Having said that, what we were looking at for today's date was to see you were in compliance. And my expectation, which I shared with you on March 17th and reiterated on April 8th, was that if you could get the property in compliance by today's date, I would not impose the $500 fine or the 16 hours of community service that I had imposed at the last hearing. And so I'm not going to require that you pay that $500 or that you perform the 16 hours of community service that was stayed. We're going to go back to where we were prior to March 17th, that you have 64 hours of community service that is now suspended, and the $2,150 fine that remains, and that will continue in effect from today's date until October 8th of 2026. It is my hope that you will continue to remain in compliance for the entirety of that period. So it's possible that the folks could drive by there on any day between now and October 8th of 2026. And if code enforcement goes by there and they were to take photographs and submit those to our probation officer could file another show cause order. And at that point, it won't be, gee, we're going to send a show cause order, and if you come in and then you clean it back up, then I'm simply not going to impose a consequence. If they provide that any time between now and October 8th of 2026 that you're not in compliance, and they prove that by a preponderance of the evidence, I will have really no choice but to impose that $2,150 fine and the 64 hours of community service that has been suspended. And I've been really reluctant to put all of that burden on you for all of the reasons that you've described, the physical health issues that you've struggled with, and to some extent, some of the burdens that you have as people get older and it's more difficult to take care of properties. But you've made such great progress. You need to stay in compliance now. Now you're there, and want you to stay there so that we don't have to go through this again, because my response will be different. It won't be one where I try to coach you or coerce you or nudge you or kind of push you to get into compliance if you fall back out. I'll just say, look, I've tried. And if they prove it by a preponderance of the evidence, I'm just going to reinstate the full measure of that penalty. Again, if they prove it. Right now, we're starting fresh. It's a nice, fresh, clean state of the order, but it won't be the same response going forward if they prove that you were out of compliance. And I just want to make sure that that's clear. I'm really pleased with what you've accomplished. I know it was probably a tremendous amount of work to get to where you are. What I don't want to see is that, a week from now, that trailer's back there and there's items at the side of the property, or that what we think was gone was a freezer or a refrigerator are back out on the property. That's going to result in reinstatement of that full measure. So that's a big deal. I'm glad Mr. Lau is here to hear that, so that there is no confusion between the two.
No, Judge. Let's do alternate universe. Mike's on the bench. This is too little, too late. You failed. Your fines are X. We will be watching you. If anything comes back here, it'll be worse. Have a nice day.
Of you that it has to stay in this condition going forward. And as Mr. Reynolds said, a hose there, or if you've got a bag of fertilizer that's sitting there, Mr. Reynolds is saying that's not causing heartburn. It's not going to cause heartburn to me. It's when other things start getting added onto that location that are different as to what it's described right now. Does that make sense to you?
It's absolutely crystal clear, Judge.
Good.
I do have one question. And this is like having the sword of Damocles hanging over your head. I need to clean out the rest of the garage, with all of my professional papers that I'll never use again and stuff like that out of the garage.
Throw them out.
That means taking them out of the garage and loading them up and getting rid of them to a shredder. And other things like that. And so I am worried.
Oh my God. She admits herself that I'll never use them again. Your professional papers, I don't know what they are, but I can almost guarantee that they were trashed the day they were made, but they certainly haven't gotten more valuable with time. And she's going on a speech about how this is difficult. You just stated going in, I will never use this stuff again. Put it in a bin.
That if code enforcement drives by and he sees me taking things out of the garage and putting them on the driveway, getting ready to move them out or sorting them out. And this is not like leaving them there for several days or anything like that, but it's the purpose of getting rid of them. Am I going to be held accountable for having loose items around my house when I'm actually working on something? Or if I have a big weed pulling project with the young man who helped.
Okay, that's funny. That's funny. But that would actually be more valuable than whatever her work papers are. It really would.
Me do that, and there are bags full of weeds laying on in the yard for a day or two before trash comes and picks them up. Again, am I going to be dinged for that if code enforcement drives by, or if some of my neighbors complain about that?
Yes.
So
if it gets in front of me, yes.
I mean, there's a logical reason for these things being
well,
there.
but there are other ways that you can accomplish without having loose items on the property. For example, if you've got a young person who's helping you pull weeds or do anything else on the property with bags that are going to have things inside of those bags, have that person, as part of the project, put those bags either right out, the night before you have your compost get picked up by your trash service. They go out in the very spot on the driveway where the rest of people put their items.
That's what I would do. That's what I would do.
That's fine. If it's just laying multiple bags across the property that are just sitting there for days and days. No, but make sure that you're clear with anybody that's working on your yard. Pick up what wrap up your day by
that. I'm sorry, but that is absolutely fitting. Judge Weak Sauce it is perfect. This guy, I've watched 75 million hours of his stupid court. And I will say this, he's not a dumb guy. He's an intelligent man. He generally makes decent rulings. I really don't have a problem with him. He appears for all the world to be a very nice person. I could have a beer with him and it'd be fine. It would be pleasant. Skosh on the boring side, probably, but pleasant. I don't have any problem with him. Except he's weak sauce. That's it.
The last step of what that person does, which may not be the same as the neighbors because you're under a different process. You're under a more strict regulation from the court. Make sure that you tell the person who's helping you that they need to wrap themselves up enough at the end of their day. So planning it out, so that they can put everything into the bags and move those bags. And if tomorrow is the pickup day and you put them out front for pickup of the trash, fine. If not, then you're going to need to put them inside the garage and then move them from there. But leaving them out is going to it creates too much ambiguity for me to say, yeah, go ahead and do that, because a day or two becomes longer because the trash doesn't come or somebody misses something. So it's going to have to be really crystal clear. I would rather not have to do this, but I think the only way to be really clear and have no ambiguity is if it's the day before and there's bags of weeds or trash, whatever it might be, and they go out to where the trash would be picked up and they're picked up the next day, not going to be a problem. If there are papers that you're working on, and I have no idea what your garage looks like, but my sense is from prior conversations is there's a lot in there.
And here we are with more
that you
prospective
have
rulings.
A place to put those documents that goes directly from your garage into a truck or into whatever document or thing that you're going to utilize to get them.
Judge,
so they're not sitting
we'll
loose
deal with it
on the
when we get
property,
there.
because that's what the rule says. No loose items or loose property on the premises. And so that remains the case. And so you'll just have to think of a better way to do it than saying, I'm going to move these out into the driveway, and then from there, I'm going to work on them, because that puts you in a very difficult position. And knowing what you have, it could end up being, okay, I'm going to move here. I got a box of papers here. I got a box of papers here. I got a box of papers here. And I'm utilizing those so that I can figure out what I want to keep. You're going to have to be much more disciplined in your approach to that, so that you can move them and they go from garage to a truck that's actually in a truck, so that if you're taking those to be shredded somewhere, you take them to be shredded. If you're going to be having someone come to shred them and you're hiring a company to come with a shredder, then you're going to have to think how you can do that so that you move them within the garage and then you move them out when the person comes, so that they're not sitting out there for a day or 2 days, because that's what has led to some of these problems. Someone said, you leave some items and then the person gets sick, or you have the refrigerator and it turns out that we thought someone from Excel was going to take it, but they didn't take it. Now it's going to be, we've got these items that we think the shredding company is coming, but they don't come. And now you've got boxes all over the property and they could be a week or two. So I just don't want to leave that kind of ambiguity with it. Does that make sense?
There is no ambiguity there, and I wouldn't have done that anyway. Leaving papers out means, you know what the winds are like down here. It means papers all over the neighborhood. So no.
Right. And I could see you having boxes of papers is what I really envision, that you'll have boxes of things that you're putting now in your driveway or on the property. And that would be technically a violation. And I don't want to submit you to that kind of issue. And so my advice to you is plan it out enough so that those items are going from the garage that you've decided are going to be shredded. Don't
expect future breaks.
Place where they're going to be shredded, either the truck that gets moved or a truck that someone brings to the property that you can just dump it right in there.
Okay, thank you. It's very clear.
Good. Okay. It's not fun for anybody, and I can't speak for Mr. Reynolds, but I'm knowing him well enough to know that this is not fun for him to have to be.
It'd be fun for me.
Strict in his approach, or me being so strict in our approach.
Oh, it'd be fun. I love being
You've
strict.
done a good job in the last couple of weeks to make great progress, and I'm hopeful that it'll continue to be that way. Now, we do have to turn our attention for you legally to address the other case, which there is nothing decided yet on that. It's just a charge. It's an allegation. I've advised you of the charge that was pending. I haven't advised you of the second charge. We could go forward with that today with me simply advising you of that charge, and then we could continue it on so that you would have time to speak to Mr. Reynolds about the case, since you didn't have the opportunity to have a discussion with him about that. But we do have that extra, that part of the equation, and I'm not passing judgment on that because I don't have an order on that. That's simply an allegation that's been submitted in the new case. But I want to at least turn to that so that we can begin to move that case forward. And Mr. Reynolds, does it make sense for you to have the conversation today, or do you want to hold off on that to another day? I'm open to whatever you think makes sense.
I do have some availability right now to talk to Ms. LeCompte about it. So if she feels sufficiently advised of her rights, then I'm happy to have a retrial with her right now.
So let me tell her about the other charge, since I haven't advised her of that other charge. She's only received that in writing. I'm just going to go over that charge.
I didn't understand what Mr. Reynolds said.
Oh, okay. What he said is he's got some time right now. If you have the time and want to speak with him, the first thing we have to do is have me tell you what that second charge is, because that was a new charge that you weren't advised of in the courtroom. So I want to make sure that I do that. And we won't take a plea. You won't be pleading guilty to anything. It'll just be me telling you about the charge, so you know what the two charges are. And so let me pull up that. And that's the second charge that was the 2025 charge. It's case number 2025-1045. And there was a motion to add one charge, and I granted that motion. So there's now a second charge, and that is a charge of a violation of section 635, storage, disposal, and screening of storage, recyclables, compostables, and specified other materials. I'm going to read to you what section 635 says, so it's really clear what that second charge is all about.
Oh, read it to us, Judge. Tell her she's dirty. Come on, Judge. Tell her she's dirty.
So you'll recall there was the section 633 charge, which was accumulation of trash. And there's also now a charge of section 635. And it says, section 635 says, no person shall store trash, recyclables, and compostables except in containers in a manner so that they are not overflowing, their contents are not scattered by animals, wind, or other elements, and so that the containers remain closed except when being filled or when opened in order to allow for collection. However, large and unusual items may be stored for collection in the manner set forth in paragraph 6 of this section. And then it goes on to say under subsection A2, store trash, recyclables, and compostables except in containers that are in a location so as to have minimum possible impact on nearby property. So it says no person shall store trash, recyclables, or compostables except in containers that are in a location so as to have the minimum possible impact on nearby properties. Subsection A3 says no person shall store or locate trash in plastic bags in alleys. Subsection A4 says no person shall store trash, recyclables, and compostables in a manner that allows putrid odors to emanate from the property. And it goes on from there. So you'll need to look at section 635 to go through all of the ways that potentially the factual circumstances from the city constitute a violation of section 635. Like I said, we're not taking a plea today. I just wanted to put you on notice that that's the other charge. And it's not for me to decide whether there's a violation or not. The city ultimately has the burden to prove by beyond a reasonable doubt of your guilt of either of those charges. But it may be worthwhile for you and Mr. Reynolds to have a conversation so that you can at least discuss the status as of now. And then perhaps there'll be a discussion on what your plans are going forward. But that'll be entirely up to you with Mr. Reynolds. And we obviously have Officer Cochran, who I believe was the officer that initiated the case for that March of 2025, March 5th of 2025 allegation. Does that make sense to you?
Judge, I need to read those statutes myself and
Sure.
understand them, because as you're reading it, I don't really, it doesn't comport very much with the reality that I see in around my house and in my backyard. So I really need to read that. I need some time to digest it. And as I suggested to Mr. Reynolds, we could schedule.
It doesn't comport, meaning my place is still isn't in compliance by the way I read it. Yeah, you're right.
A pretrial or a pre-hearing, whatever it is. I'd like to have a discussion with him about just exactly what needs to be remediated and on what, and specifically on what time schedule. So if we could talk about that, I would be very appreciative, but I would not like to do that today because I don't feel prepared to.
And do you have access to the internet so that you can pull up that section 635?
It's 16.5.
No, 635.
635, and it's in the Boulder Municipal Code.
Boulder Revised Code.
Okay. Yes, I have access. I can pull it up.
Okay, that'll give you and I understand you wanted to look at the legal basis for the charge and consider the factual circumstances that are part of this. No need in my mind for the delay too long for at least that initial meeting, because you should be able to look at the ordinance in a day or so. Look at it, consider whatever other evidence has been provided to you. Now, have you already shared the photographs from connected with that case, Mr. Reynolds? Is there discovery that needs to be followed up on?
I believe that we have, however, we haven't received a discovery request, but I am. Yes, we've shared the photographs now that I'm thinking about it, and it's mostly going to be about the backyard.
Okay.
I've sent her.
So you have that information from Mr. Reynolds. Why don't I'm going to give you another court date, which will be a date for you to come and decide whether you want to, if you've worked out an agreement with Mr. Reynolds and you decide that there's a disposition that's been entered. We'll have what's called a disposition and a trial setting.
No more complicated than that.
That date I can set out a little bit further out, because that'll allow you and Mr. Reynolds to have a conversation that separate from that and prior to that date. And then hopefully you'll be able to work out a resolution. If you can't, you always have the right to plead not guilty to the charge at that date. And then you could set it over for trial. I think we've talked already about your right to have hire an attorney if you choose to, or apply for the public defender. And you indicated that you don't believe that you will qualify for the public defender. But I just want to remind you, you always have the right to seek counsel, or if you think you could qualify for the public defender, you could apply for the public defender.
If she owns that property,
we're going to
she
give you a
doesn't
court
qualify.
date, and I'm thinking to set that 2 to 3 weeks out. Do you think, Mr. Reynolds, does that make sense from your
Unless
perspective?
it's mortgaged up, it probably is.
2 weeks would be my preference rather than 3.
All right, let's reset that for 2 weeks out if we have a date. So I'm going to look at that, and then let me just take a look at our monthly court calendar. These Tuesday dates seem to work pretty good. So we're today's April 22nd. I would think if we did the first week of May would be May 6th. We could be in the same situation. There's a trial that afternoon on a rental license case at 1:15, which would probably be up by no later than 3. So we could do the May 6th at 3 p.m. we could set. And that would be just a date for what we would call a disposition and trial setting date, where you would come in. If you worked out an agreement, we'd have a sentencing hearing. We'd take a plea of guilty if there was going to be a plea. And then we have a sentencing order that day if the 3 p.m. date works. But let me just check to Mr. Reynolds. How does that work for you?
Doesn't work well for me, but if that's a dispo date, then it's more for Ms. LeCompte than it is for me. So I don't think that I am necessary for that hearing. And she has my email, so if she wants to talk with me, she can email me and set that up.
Okay.
Separately. But
Oh,
I
hey,
would say
baby,
that's
email me.
I won't be there at that time, but
Well, if we have an order, it might be need to have it doesn't necessarily need to be you, but I think we should have a pick that date where whoever the judge or the prosecutor is going to be on can be there, because if there is an agreement, we want to make everybody, if questions arise. So we've got the 7th, May 7th, we have a slot at 3 p.m. we could do. We have which could convert from a jury readiness conference. So I have that day and we also have May 5th, which is 13 days from now, which we also have availability at 2:15. So any of those days, but I do think it would make sense to make that dispo and trial setting on a date when you'd be available to participate.
so the May
Judge,
5th.
Judge, I would wanted to talk to you about seeking legal help. I will need to talk to a lawyer.
No.
When I first said I felt it was inappropriate for me to claim that I was indigent. I used a word that I think maybe you misinterpreted.
She's
I
indigenous.
said it would be shameful for me to receive help when there might be other people and what I meant was other people in greater need than me.
Mm-hmm.
I in no way meant to suggest that I thought being indigent was shameful. Although I thought that was
Oh my
what your
God,
interpretation
nobody cares.
was.
Shut up.
No, for me, it's always going to be, it's a relatively concrete decision.
Being indigent is nothing to celebrate. Let's start with that. It isn't necessarily shameful, and playing footsie with all this stuff is annoying as hell. And you need some shame, my friend. That's the whole problem here. Is you don't have any shame.
We have you fill out an application, you give your financial information to the court. It'll show whatever your monthly income is, which includes if you get Social Security and or any other kind of pension that you receive on a monthly basis. And then you're required to give some information about your financial asset information. And it's not a question of anything other than just looking at the state statute or the indigency guidelines are set by Supreme Court and looking at your financial inclinations or information. And then I decide whether you're entitled to public defender representation. So
Oh my God.
it's not something that you should be determining, well, others might have a need. If you fall into the application and your income is less than what is required, then you're entitled to the public defender. And if you're not, because you're over the income information, then you won't be. So if you want to apply, that's perfectly fine.
Yes, I would like to.
Okay, so I'll just ask for Sabrina to email to you the indigency application. You may have to, if we don't have one, but there is one in the other case.
Oh my God.
Yeah, so you could probably just
Give her the application,
copy
fill it out or
that and
don't.
then forward it to
Next.
Ms. LeCompte and Mr. Compton. She can then fill out the application. So as soon as I receive that, I can make a determination. So I don't want you to wait very long because If you are wanting the public defender, then I will change the date that we set, because our public defender is someone that we have come on the second Tuesday of each month, which would be at 9:30 on May 13th. So right now, I could choose a different date, and then I might have to reconsider that once I see your application. But let's assume for right now you may or not be entitled. I've had 2 hours of information last night. It is starting to show from my ability to use the words.
Yeah, let's go through all the hypothetical scenarios.
Struggling. But let's look at the possible options. May 5th at 2:15. I think Mr. Reynolds was starting to say that would not possibly be a possibility, or is it?
I apologize, Your Honor.
Excuse me, is this for the disposition and trial setting?
Yes.
Okay.
Did you say May 5th?
May 5th
5th, okay.
or May 6th at 3. So I've got 2:15 on May 5th. I've got
Judge,
3 at 15.
I'm going to be wearing a
May
sombrero
6th,
on that day.
or
And
3
that's all.
p.m. on May 7th.
What happened to the May 13th? That would be preferable for me.
I'm not going to set that. I may end up having to reset for that date because I want to move this forward. We've been continuing it since March 5th without any disposition trial setting, so I want to move it forward. I want to do 2 weeks.
Like a daisy cutter, just to make
if
sure.
you end up being entitled for the public defender, then I will reset you for the May 15th date.
Okay, so these are Tuesdays, and is this the 7th?
I've got Monday, Tuesday, and Wednesday, May 6th through 7th, May 2:15, May 15th at 2:15, May 6th at 3, or May 7th at 3. And I've asked Mr. Reynolds first to see what works for him.
May 5th or May 7th.
All right, so which one of those would work for you? May 5th at 2:15 or May 7th at 3:15? 3 o'clock.
Actually, the Wednesday date, May 7th,
All right,
and that is at what time?
3 p.m.
3
So,
p.m. Okay.
Sabrina, you can change that to a dispo trial setting. Let's go ahead and
I love
not
all
have
these
anything else
defendants.
lifted. So you can
We have
get
no
rid
life,
of the jury
like
readiness.
nothing
conference
going
date.
on.
Make that for a dispo trial setting at 3 p.m. on May 7th. And she will also send you the indigency application, and you can submit that to the court. I can make a determination as to whether you're eligible for the public defender. And if you are, then we will reach out and reschedule your case for May 13th at 9:30 a.m. Just so you know, that's when our public defender would
Mark
be
your
here in the
calendars.
morning of
Prepare
May
to be
13th,
disappointed.
and that's her hard deadline of when she's available.
Okay, and so then in between the now and May 7th, I will need to schedule a hearing or a conference with Mr. Reynolds.
That's right, and that won't be on our docket. That's just between the two of you. You can reach out to him by email and see if you all can have a conversation prior to that date.
Okay, and I will do that as soon as I have had a chance to read the
we don't care.
the regulations.
Sounds good.
Okay, thank you so much.
All right. And I'll make it clear on both the other cases that we're back to on 2020-250 that I'm going to resuspend $2,150 on that case.
Why?
And resuspend the 64 hours of community service, which is good news because that means you don't have to pay anything that I had previously imposed. And the new case we will move forward with
Oh my
on
God.
May 7th of 2025, unless there's an indication to reset that for the public defender. So I think you can leave this meeting now unless you have any additional questions for me, Ms. LeCompte, and we will see you. Look for an email from Sabrina for that May 7th court date.
Okay, thank you very much.
You are welcome. And Mr. Reynolds, thank you for your work. Mr. Lau for sending us the photographs.
Thank you, Your Honor. Thank you, Sabrina.
Well, there you have it, people. We are up to date. There's another date pending. Lau's got to have another date pending too. I wasn't impressed. I don't get how they acted like everything was in compliance. It just didn't look like it to me. It didn't look like it to me. And then the usual routine. I mean, that gets me. It's in all these cases. We have these defendants who have absolutely no life whatsoever. Nothing going on. Absolutely nothing going on in their life. And then they get they start making all these demands when you try to set a date. It just cracks me up. It's like it's their Super Bowl. It's their only chance for someone to take them seriously because of the formality of court etiquette. Nobody else ever at any time in their life asks them if they're available because they don't care. but a judge kind of has to do it a little bit for due process reasons. She's insufferable. All right. I'm actually glad I got that in. Thank you for coming out. I appreciate it. I can't believe we've done that. What is that? Number 11? And some of these are really long. Oh, thank you. Thank you. But as you can see, this thing's not over because we're only talking about her too. Lau's got dates. That's why I really wanted to see the other pictures because you know the BBT is out there. You know they're like 4 or 5 like mid-80s trucks parked in the vicinity. All right. Thank y'all for coming out. Behave yourselves.